I'd like to welcome everyone to the University of Tulsa College of Law on this beautiful snowy day. I am from Chicago, so I was going to really get upset if I got through another season with no snow on the ground. So I was very happy this morning. Before I introduce this panel, just a brief commercial announcement for the College of Law. We are hosting our annual Hager Lecture on March 6th in the evening, and our speaker is Michelle Alexander, who published a book last year called The New Jim Crow that was a New York Times bestseller. That's going to be over in ACAC because we are anticipating a fairly large crowd, and we really hope that all of you here can join us and spread the word because it's going to be a very interesting lecture. So today I have the privilege really of welcoming you to what I think is sort of the ideal of what college campuses and academic settings can be. This group of distinguished scholars, which Professor Spoo will introduce in a moment, has spent this morning and will spend this afternoon in a sort of closed session in a conference room there, discussing the ideas and pushing each other's work further and using each other's brain power to push the work. And that, for those of us in the academy, I think those afternoons, those evenings, those days for me were among the most enjoyable. So I really want to welcome those guests here and welcome those from other departments here, and thank you for participating. It's also really great for me because the law school is part of such a vibrant university, but what's amazing is sometimes we don't make the 3 or 4 or 5 minute walk across campus to visit with each other about what we're doing. So it's really great to see so many colleagues from across campus, from academic departments, from the Gilcrease Museum, from McFarland Library, and to welcome you all here today to interact at the law school and interact with the guests to the law school. And I also just want to take a moment to thank Professor Bob Spoo, who's just really a significant part of the intellectual life of our community, and his work, although I'm not an intellectual property scholar by any means, his work really provokes me and many of your work, and Peter gave a presentation to the faculty yesterday. Many of this work really provokes me to think about my own world, which is international law, in particular how private lawmaking communities really create norms that impact public sort of official law. That's what I like thinking about, and I think particularly with the fair use doctrine, that's a lot of what is going on in this community. So I want to welcome you and turn the podium over now to Bob for the panel. Thank you.
Thank you very much, Dean Levitt. I don't know if there are some folks in the wings who might be able to filter into some seats up here. I hope if you can, you will. Let me add my welcome to the deans. I am really, really delighted we all are here at how large a group has shown up. I guess you felt you had to show up because we're such a large group, so you had to match us in some sort of ratio. Well, you've done it. Thank you for doing so. What we're going to do today, this is very much about you today, as much as it is about us. In fact, we have been in our closed chambers talking about you, that is to say, talking about communities who need in some way or another to make use of copyrighted works in situations where either they cannot or really need not obtain permission for that use ahead of time or afterward. And that's what we're talking about. Fair use is what it's called in this country when you make an unauthorized but lawful use of somebody's copyrighted work in some form or format, in your own work. And I think that probably everybody in this room has done that, probably even sometime in the last couple of days. We simply do this as a matter of very much now digital, online, emailing, and things like this going on all the time, and more formal projects. So what we have been focusing on We have a number of very, very diverse group of people. I'm going to introduce them very, very quickly in a moment, and then they're going to start talking. What we're going to do is we're going to have, we have a total of 12 folks who have been part of our group of discussants. We're going to have 5 of them make very brief statements to you about an aspect or a perspective on fair use. And then what we would like to do is to open it up to the audience, to you, and have you come back to us with your ideas, your interests, your concerns, your fears, your solutions to fair use. Anything that you would like to talk about in terms of this fair use idea. We have been focusing our thoughts and energy on fair use in the context of humanities scholarship and teaching. Specifically even modern literature scholars who very desperately need to make fair use because much of the work they write about is still copyrighted, whether it's a text or a poem or a film, they still need to. And so let me very quickly introduce our group. Without telling you a great deal about them, I could go on for hours about each one of these people, but I won't in the interest of time. And I'll do it in alphabetical order. Adrienne Alexander is R.M. and Ida McFarland Dean of the Library here at the University of Tulsa. Kevin Detmar is W.M. Keck Professor and Chair of English at Pomona College. Sam Hallaby is not up here. I believe he's coming in a bit. Sam Hallaby is one of our colleagues here at the law faculty, a fairly recent addition to our law faculty. Peter Yasi, that Janet has already referred to. Peter is sitting right next to me. He is a professor and director of the Intellectual Property Clinic at Washington College of Law at American University. Sean Latham is our own professor of English and editor of the James Joyce Quarterly, the Pauline Walter Professor of English here at TU. Brendan O'Neill is there on the end. Brendan is literature and cinema editor at Oxford University Press in New York. Kate O'Neill is a professor of law and an intellectual property scholar at University of Washington School of Law in Seattle. Robert Pickering is applied associate professor of museum science and management and anthropology, and among other things, senior curator of the Gilcrease Museum here in partnership with the University of Tulsa. Tamara Piety, who I think may be, she joined us or she may be in the audience or joining us in a bit. She is also a colleague of ours. She is a professor and associate dean for faculty here at law. Paul K. St. Amour, who is right next to me here, is a professor and a graduate chair of English at University of Pennsylvania. And Laura Stevens here is professor of English and editor here at TU of Tulsa Studies in Women's Literature. So what I'm going to do is begin right away with one of our speakers, and we're going to speak in fairly rapid terms and get the ball rolling. And we're going to begin with Kate O'Neill.
Thank you, Bob, and thank you all for making my visit here possible from Seattle. I was delighted yesterday to come down and see all that warm sun, and I thought, wow, what a great city, and I'll get some light on my face, and then what's happened this morning, I don't know, but in any event, I'm very pleased to be here. My job in the first few minutes here is to just give you a little introduction to the legal doctrine of copyright fair use. As most of you probably know, modern U.S. copyright statutory protection attaches to original expression the moment that expression is fixed in any medium that would permit some sort of reproduction. And with modern technologies, the manner in which reproductions may be made and disseminated are, of course, very numerous. Copyright, protection that's given to that original expression, is often described in the familiar property metaphor as a bundle of sticks. And in that bundle of property right sticks, one right enables the author or creator of original expression to decide to publish the work initially. It's called the right of first publication. It's very important. Other rights, more familiar, are the rights to authorize or to enable copying in whole or in part, and to license derivative works, so movie from a novel, for example. You may have noticed that I've been using the word enable, that the copyright that attaches to original expression is, at least in theory, designed to enable the dissemination of that expression by giving a property interest to the creator so that they can get money in exchange for authorizing a first publication, or in exchange for permitting copies to be made, or in exchange for licensing a derivative work. But therein lies the rub, because in enabling that giving that cultural incentive to create and then disseminate work, one also the law erects an obstacle to subsequent creators who might want to build upon, quote, use, comment upon the original work. And that's where the doctrine of fair use comes in, to mediate between the interests of the original creator and the secondary, I shouldn't say secondary because that somewhat diminishes them, the subsequent user. Fair use is also commonly described as the glue that accommodates copyright on one side in our legal system and the First Amendment on the other side. Copyright giving an exclusive right to retain or license one's works, First Amendment giving all the rest of us the right to engage in free speech about that existing work. And without the doctrine of fair use in our system, it's commonly thought that we would have a irreconcilable collision between copyright and fair use. So what is fair use? How is it defined in the law? It's codified at 17 U.S.C. Section 107, which some of us here have practically memorized. And it has four elements. It permits the unlicensed use of copyrighted material. And the four factors that courts are to consider in deciding whether unlicensed use is or is not fair involve the following. The nature of the underlying copyrighted work in the first place. Often there's some distinction made between works that are primarily factual and works that are particularly creative, for example. The purpose of the use. The person who's saying, I'm entitled to use this material without permission, what is their purpose in doing so? Are they commenting? Are they explicating? Are they making fun of the original work? A third factor, which is more or less, it's perhaps not very useful, is the amount and substantiality of the work that's taken. And the final factor is the effect on the market for the original work. And the courts, these four factors are put into a rich stew of case law that the courts are supposed to examine and consider. There is no one factor that's more dominant, at least in theory, than any other. Particular issues that may concern us here today that arise in fair use legal doctrine are particularly focus on whether there's a different caliber of fair use depending on the genre of the original work or the genre of the using work. Is poetry, for instance, more protected than a work of history? Are works with cultural or religious resonances, perhaps in certain communities, more or less entitled to firm copyright protection without fair use than Other works are some examples. A particular interest of mine is the distinction that's arisen in the case law between the use of published works on one hand or unpublished works on the other hand. And that's interesting in part because that issue in copyright law often teeters over into concerns with privacy. So, for instance, if a scholar wants to use unpublished preliminary drafts of a poem as a way of explicating a poet's process of creating, is that more or less permitted? Another example is a historian who wants to go and use unpublished letters of a famous person. Does that or does that not invade the privacy interests of the person or his or her family? And should that concern about privacy have anything to do with copyright? These are some of the complexities that get into a discussion of fair use. I'll close with giving you a little bit of a metaphor for thinking about fair use. If you imagine in our culture the first expressor as being like a mountain spring where this fresh water burbles up out of nowhere and creates this lovely stream that begins to trickle down the mountainside. Other writers, other creators bring tributaries into that stream, and it broadens and deepens as it rushes down the mountainside. At some point, though, there are other creators who want to dip a cup into that stream, to take it out, to nourish themselves, and perhaps to create and grow some wonderful other crop or resource over here on the side. And hopefully then that work then is reintroduced, perhaps after a long filtering process, back into this stream of culture running down our mountainside. If one thinks of expressive culture as this continuum where everything is contributing to everything that has come before it, and people are extracting water from the common source but then also contributing back in, fair use is one of the legal doctrines that allows us to think about how much that downstream user can take out without permission. And with that, I think I will close. Thank you.
Thanks so much, Kate. I just want to say what a pleasure it is to be up here and to have had a chance to spend an evening and a morning with some old friends and with some new friends, and also to observe that this panel is, among other things, a testament to Bob Spoo's capacity for friendship. And I guess I'll just also put in a plug for the importance of friendship to our intellectual work. I think it's something that we don't celebrate often enough, but I think what you have here is, among other things, again, a kind of a testament to the way that those two parts of our lives can really fruitfully interlock. As one of the rogue humanists on the panel, I wanted to just offer a couple of invitations about maybe skew or unlikely ways to think about copyright that may be particularly invitations to those of you who are fellow humanists here and not necessarily intimately acquainted with the fair use doctrine from a legal perspective. The first one will be, I suppose, counterintuitive, and the second one we could call counterfactual. Who here has read or heard of Michel Foucault's 1968 article, What is an Author? Is that something that some of you know of? It's a famous article in which Foucault, among other things, called for a study to a greater degree of attention to the figure of the author as a possessive individual, a consecrated figure to whom certain kinds of powers and also rights were attached. And that was an immensely important piece of writing for the study of intellectual property and the production of culture. It really asked us to think historically about this figure of the author. When did this figure emerge? How did this figure become consecrated and in certain ways gendered and empowered? I've actually gotten recently interested in another dimension of Foucault's work that I think it's time for us to pay attention to and respect to intellectual property law. And that is the slightly later work from the 70s around this concept of biopolitics, which is to say that states in the modern era are not so much in the business of taking away life, but rather of making life happen, particularly at the level of populations. And Foucault observes that the sciences of demography and other population-related sciences emerge in the 19th century and become a really essential part of the governmentality of 20th century states. Now, we don't, I think, necessarily associate this term or the concept of population with copyright. They seem to be kind of on skew vectors. But in fact, when the first copyright terms were being decided, they were decided on the basis of apprenticeship lengths. So the first copyright term in the UK was 14 years, which is taken to be 2 apprenticeship terms, right? The idea being that if you give an apprentice 2 terms out from the shop, then that person won't be sort of taking away trade secrets, and it was done on that analogy. When Thomas Jefferson sat down to figure out the length that copyright terms should last in the US, he sat down with mortality tables to figure out what the length of a generation might be. And so, again, even in these early moments of copyright, we see people thinking demographically about natality, mortality, populations. As many of you know, in the late 20th century, we saw a rash of term extensions, right? Extensions in the length of time that copyright lasts. In this country, that term was extended from the life of the author plus 50 years to the life of the author plus 70 years, right? So a 20-year term extension. Why did that happen in the US? It was precipitated in part by the fact that in the EU, that same extension had taken place. Why had it happened in the EU? Well, here's where things get interesting. There were basically 2 claims in the EU about why they wanted to extend copyright. The first was that copyright should protect an author for his or her lifetime plus 2 generations of descendants. And the claim went that with life expectancies having gotten longer, copyright terms needed to get commensurately longer. People pushed back and said, well, maybe this is about the age of childbearing, right? So you can sort of fight a demographical argument with a demographical argument. But that didn't go anywhere, and so the term was ready to get extended. And what I think really clinched it was a claim that had to do with a couple of national jurisdictions in Europe. In Austria and France, and I think also Germany, copyright terms had been lengthened as a result of the Second World War. And the idea was that these were the wartime years and the recovery years were years of lost productivity, and in some cases lost lives for cultural producers, and that extending the term of copyright was a way to kind of compensate either those cultural producers or their families. And so, in essence, all of Europe, and then consequently the US, and then consequently most of the world, has extended its copyright terms in relation to that lost wartime generation, which I think is kind of fascinating. It's as if the globe had been conscripted in a kind of work of mourning in perpetuity for a lost wartime generation from some countries. Why should this be interesting to us now? Well, you still hear these demographic arguments, particularly being made by rights holders, right? People who say, I need to know that not only my children, but my grandchildren and my great-grandchildren will benefit from the pop songs that I write or the books that I write. So you hear that population-related argument being made on the side of strong copyrights. And I think there's an opportunity for those of us who are concerned about that overextension of copyrights to begin thinking also in terms of population, in terms of how not just individuals, but whole communities and whole populations are constrained in their creative capacities by laws that are, in some cases, both too highly reticulated, finely reticulated, and too extensive. Just one thing I would observe as a way of giving you a sense of how this can be geopolitically consequential. If you think about the fact that our copyright laws now are measured from the death of the author, right, 70 years after the death of the author, that means in countries where the life expectancy is shorter, the raw number of years that a property right lasts will tend to be shorter in those countries, right? And if you think about the reasons for shorter life expectancies in, let's say, the developing world, what we have here is a kind of enshrinement in the law or in the consequences of the law of colonialism, imperialism, racism. And we don't talk enough about how those geopolitical traumas and legacies are really embedded in the very fiber, in the very fabric of our property laws. But I think when you do begin to think about it that way, you realize that these are haunted laws, right? They're laws that are haunted by history. And I think it's time that we start to heed the collective haunting of our intellectual property laws by the past, and to think about how they can be altered or differently inhabited, so that our creative capacities are not constrained in that way. I think I'll yield the podium at this point, and maybe save my counterfactual tidbit for later on. Thanks.
So I'm a literature professor, not even a law and literature professor, just a straight up plain old lit guy. So my comments will be even more naive maybe than some others. But in thinking about fair use, I thought about the categories of agony and ecstasy. And I think this morning in the working group, part of what we're trying to do is to think about whether it's appropriate to articulate a set of best practices for fair use in 20th century literary scholarship. And Kate, sort of late in the morning actually, asked us a pretty central, relevant question, which is, what are we trying to get done with this, right? And the thing that I immediately went to, and some other people around the table talked about, is, well, if we could do anything, I would like to prevent the deformation of scholarship that occurs because we don't have a clear sense of what is fair use. And that, especially young scholars, I think, but all scholars, in some ways, there's a kind of timidity about really pushing a reasonable fair use claim because we're not quite sure what won't get us sued. So that too much scholarship takes place in the shadow of a fear of what fair use really is. I did a book in 1999 called Reading Rock and Roll, and it was held up at the publisher for almost a full year. It was, I guess I can say, it was Columbia University Press, and it was the first book about rock that they had ever done. And in-house counsel was quite nervous about quotations from lyrics of songs. I didn't tell this at the table this morning, but it's a sort of good anecdote to illustrate a lot of what we were talking about sort of myths and half understood ideas. So after a year, what they finally told me is they gave me back the manuscript, which was, it was an essay collection. It was ostensibly complete. But they said no quotations from songs of more than 2 lines. All the quotations had to be run in so that visually nothing would call attention to itself as a quotation. And no more than 4 lines, so no more than 2 consecutive lines, no more than a couplet, and no more than 4 lines from any song. And then spent months working with the contributors trying to conform to those guidelines. There's been I think of it as sort of a don't ask, don't tell policy about fair use in literary scholarship, which is you just sort of try to get it done and hope that nobody calls you on it. And as we know from the experience of the U.S. military, that's really no way to do business. So that's some of the agony. I mean, we all have horror stories that we could tell about that. But just to point to a couple of moments of ecstasy, and I'm stealing the term ecstasy from Jonathan Lethem, who's my colleague at Pomona College. I hope that you know, but if you don't, really, you need to look at a piece called The Ecstasy of Influence that Jonathan did in Esquire magazine some years ago. It's a quite artful pastiche. It's entirely plagiarized, and you don't know until you get to the footnotes where he identifies the sources of everything in the piece, right? But it's an essay that argues for the importance, the inevitability, and in fact the joyousness of artistic collaboration across generations, right? The way that artists use other artists' material. And he makes the argument by stealing all of his words from other people. Paul talked about friendship, which I love introducing that note, and I guess I would just say that that's how I met Jonathan. I was working on a book on Bob Dylan, and was hoping to ask him to write a piece, and then I found out that he had plagiarized me, and so I pretended that he owed me, and he pretended that he did too, and he wrote for me, and we became friends and are now colleagues. So friendship forged through forgery or something like that. The other thing I was thinking about, just because I love it, and I don't get to talk about it very often, I do teach it. I was thinking about there's a guy called Greg Gillis, some of you will know, who records under the name Girl Talk. And Girl Talk is really, I think, technically Greg Gillis, and a laptop with an astonishing hard drive of music on it. He does this live as well as making recordings. In 2008, he put out a record called Feed the Animals. It's available for free. I think the website is called illegalart.org. And it's entirely sampled. It's built, from beginning end of samples. It's about 73 minutes. It's deliciously fun to listen to, and I think it just gets better and better as you listen to it. Part of what's interesting about it, I think, is that Kate talked about how understanding of fair use, whether appropriately or not, it seems like it's affected or inflected by genre, right? That somehow poetry gets a different kind of consideration than prose does. Well, music, even more so, right? And probably remember the days of clearing all of your samples. Greg Gillis doesn't clear any of his samples, and he has not been sued for a 73-minute piece of music that's made up entirely of samples. And then the clever thing about, it would take me longer to set it up than it would to play it, but the first second and a half of Feed the Animals, it's the only time, I don't know how to explain this, at any given moment there are 3 or 4 or even 5 different samples being layered on top of one another. So it's not just samples glued back to back, but in fact they're layered in really interesting ways. There's only one moment in those 73 minutes where there's only one sample being played, and that's the first second and a half, and it's the first second and a half of Roy Orbison's "Oh Pretty Woman." It's just the drum from "Oh Pretty Woman." And yeah, as IP scholars know, "Oh Pretty Woman," when 2 Live Crew did their parody of "Oh Pretty Woman," and that was adjudicated, that became an important landmark decision, saying that parody can be fair use even if you make money off of the parody. Right? So the way in which Girl Talk is sort of signaling at the beginning of this big, kind of crazy, fun, ecstatic, fair use symphony, then he knows entirely. He knows his IP history too, and he's going to exploit the fair use doctrine for his own ends. So you should listen to that too. So read Jonathan Lethem, The Ecstasy of Influence, and listen to Girl Talk.
Homework.
So when I started doing copyright law a long time ago, most works enjoyed an effective protected life of 28 years. And we are now, as you've heard, in a very, very different copyright environment. And the expected copyright life of any given contemporary work is likely to be in excess, and sometimes well in excess of 100 years. This has been a tremendous game changer, and it has made this notion of fair use, what can you do with contemporary work in creating your own work, in adding something to the stream, as Kate so beautifully described it, given that a lot of what you are likely to want to work with is protected and is likely to be protected until well after you're dead. So the fair use doctrine, which has been around for a long time and has been intermittently more and less important in U.S. law, has assumed a tremendous amount of importance in, let's say, the last 25 years or so. And the word on the street about fair use is that it doesn't really serve the needs of creators, scholars, and teachers very well, that it's too situational, that it's too uncertain, that the statutory formulation is too vague, that as a result it's impossible to predict outcomes, and so on and so forth. That very negative sort of word on the street is no longer, after the last 25 years or so of judicial interpretations of fair use, entirely valid. We now have a new fair use doctrine, which is keyed to the general concept of transformative use, that's enormously broad in its potential reach, that applies as a kind of unified field theory across all kinds of material and with respect to many, many kinds of uses. The news about fair use, if you look at the courts, is really very positive, but still, in various communities of practice, with the very honorable exceptions of heroic figures like Greg Gillis and Jonathan Lethem, the word in most fields of practice is still shadowed, let's say. There's still a lot of uncertainty in the world and confusion and unnecessary disagreement either about what fair use is and isn't good for today. And so the question that I and my collaborators at American University, and in particular my main collaborator, Pat Aufderheide, and I have been working on for the last decade or so, is the question of how to make fair use, which we now know incidentally from the courts is integrally related to the First Amendment guarantees of free expression, how to make fair use real, how to make it accessible to a variety of different kinds of practice communities in the arts and in scholarship and in education. And this is where Dean Levitt's earlier remarks about the importance of new kinds of norm making come into play. Because the work that we have been doing over the last decade has involved helping different discrete groups of creators, scholars, and educators articulate and publicize for themselves their shared values, which tend to be, in some ways, quite centrist and non-controversial, but nevertheless have to date gone unstated, about what is and isn't responsible exercise of fair use in connection with the fulfillment of whatever their mission may be, teaching students, making art, advancing scholarship. And the way we've done that is by working with professional organizations in a variety of fields to help them to create codes or statements of best practices in fair use. The earliest of these issued was the Documentary Filmmakers Statement of Best Practices in Fair Use from late in 2005. The most recently published is this one, the Code of Best Practices for Fair Use in Research Libraries. And in between, we've worked with K through 12 teachers and open courseware providers and dance archivists, and several scholarly organizations, the ICA and SCMS, with poets. And now, currently, we are engaged in doing this work with journalists. That code should be out in a few months' time under the sponsorship of the Society of Professional Journalists, and we are beginning a major project with the College Art Association with respect to best practices in fair use in the visual arts. Now, it's fair to ask, what comes of this exercise? And the answer appears to be a lot. These codes, once they are announced and once they are made known in the field, are affecting practice in all kinds of what we think are very positive ways. The members of the practice communities that generate these documents, which are very much of, by, and for those communities, are liberated to a great extent to do things which they have always believed they were entitled to do, but never knew that their professional colleagues also supported and believed in. So we have new forms of scholarship as a result of these codes. We have new forms of filmmaking. New subjects are being tackled. New modes of production are being employed. Library practices have changed dramatically and positively and are continuing to change as a result of their efforts. So within the communities, these are very powerful documents because they're a means by which professionals speak to one another about their shared values. And beyond the communities, they're effective too. Every group of creative professionals has to deal with some set of gatekeepers, some authority figures who stand between them and their ultimate audiences or the other beneficiaries of their work. So for filmmakers, it might be a distributor or a broadcaster. For librarians, it's likely to be university general counsel who make policy for libraries. For the dance archivists, it turned out that funders were the big problem because their work depends very much on external funding, and funders were very concerned about whether or not the projects that they were putting forward were in fact copyright compliant. Everyone has a gatekeeper or multiple gatekeepers with whom they have to deal. And perhaps the most important for audience for these statements of best practices has been the gatekeeper community, who have seen that, in fact, they can relax their policies a little bit. They can be more open to the fair use doctrine as it is today, as a powerful right of users without running any substantial additional risk. It remains to be seen when and if courts will have anything to say about the importance of these documents as a source of information about law. We suspect eventually they will, but so far, after 10 years, it simply hasn't come to that. Why? Because no creator, no scholar, no teacher, no librarian operating overtly within the four corners of one of these states of these codes of best practices has ever been sued, let alone lost a lawsuit. So maybe that tells us something about the future of fair use and the power of collective action, the power, in effect, of a kind of friendship, to go back to Bob's original theme, in this space.
Thank you. Before we turn it over to you, and we very much want to talk to you about fair use, hear what your questions, your ideas, your thoughts are, and at which point our fuller panel can hopefully engage with you as well. I want to mention two things. First, a practical, very important matter. We are grateful, the law colleges, and I am personally, to the Chapman Trusts that not only permits my chair to happen, but events like this. We thank the Chapman Trust for this. Sharon Bell, Greg Gray, who administer that. It's a terrific opportunity to bring folks like this here and make these events happen. And I wanted to just add a very, very brief thought. I'm myself fascinated by norms. We talk about norms. Informal norms have been mentioned a couple of times. Dean Levitt is very interested in norms. And norms are things that are sort of rules that grow up on top of the law, next to the law, sometimes in the absence of the law. There's a whole legal scholarship that exists, although we teach our students about the law, and that's what they're primarily here to learn about. There's a whole world, and legal scholars write about how, it's much more important in a practical way, all the things that we do that we are not compelled to do by law. Why do we allow somebody to cross the street in front of us? We have many embedded sense of what is right and what is wrong. Let me tell you something that, very briefly, that I have been fascinated with the last few years, and I've got a book coming out in a few months about it, and that is, throughout much of U.S. history, copyrights, U.S. copyrights were not recognized for foreign authors at all throughout much of the 19th century, and then in limited ways throughout much of the 20th century. And I got interested in this, so interested that I discovered something that scholars had begun to work on, and I dug very deeply into it, and that is that in the absence of copyright law, and you'd think that that would mean that publishers throughout the 19th century would make a land rush, a gold rush for these very popular works by Charles Dickens and Sir Walter Scott and Jane Austen and so forth, that there would just be this massive publishing. What they did is they began to recognize among themselves something called courtesy, trade courtesy. They started the first publisher to say, hey, I got that Dickens novel, or I published Charles Dickens, so others, you have to lay off Dickens. They started recognizing each other's courtesy title, courtesy copyright. Copyright didn't exist, anybody could do it, but they developed a set of norms, a community set of norms that really recreated the world of copyright upon an absolute vacuum of copyright for foreign authors. Now, what we're doing here is a kind of inverse of that. We're thinking we very much have the law. In fact, many people feel we have a supersaturation of legal rules about copyright that frighten many users. And what we're talking about is taking fair use, which is definitely part of the law, but building on top of fair use a communal normative understanding of what fair use is that will allow communities to focus fair use and use fair use. So I see this coming around as a kind of yang to the yin of my previous research that is a very gratifying and again I think friendship-based or community-based thing. So thank you very much, panelists, and thank you. I'd like to open it out to questions right away and see what we can talk about. Yes, sir.
Going back to law school days a few years ago, the norm was, well, you can copy anything. You're in education. We're here. You can copy stuff out of any book, anything, for your own private use to further the purpose you're here. Is that one of the norms, or is that true or not? But a lot of it was going on. I know that.
In the classroom context?
Well,
or in the school?
Doing your own research or just whatever, you'd go down to the copy machine and copy up copyrighted work right and left to study with, and you didn't want to mark up the book, the library book, you'd make it and then take for your own private use.
Yep.
And that was okay.
So I think there are two big dimensions, or almost two hemispheres of fair use. And one has to do with what you described, that is private use. The idea that there are certain activities that are privileged because they are only for the personal benefit and consumption of the user. And that notion is under a little bit of pressure and threat right now, but it largely remains intact. Where the big changes have occurred is really in the other hemisphere of fair use, which involves uses that are intended to go public. When, in writing my book of criticism, I want a quote from song lyrics or from poetry, or when, in writing my art history monograph, I want to show what that Picasso picture that I'm writing about looks like in order to support my discourse. Or in teaching, when I want to use copyrighted material and put it on my class website so that my students can study it and prepare better for class discussion. None of those are private uses. All of those are uses that have a public dimension. They go beyond the user individual, and that's where the contestation around fair use has been in the last 25 years, and that is the area in which the law has developed so dramatically since about 1990 to be far more embracing, far more flexible in recognizing the cultural significance of those activities.
Yes.
I believe it was discussed when you were standing up here regarding the lack of standards regarding publishing and fair use, and that it's just kind of, I see it, I know it when I see it type of thing. Can you explain how you make those decisions for young authors and researchers?
I mean, there are some guidelines that I can use in certain cases. For quoting copyrighted poetry, for instance, the rule is if it's being explicated and it's illustrating the scholarly point, then it's fine. For the film books I work on, any screen grab that's made from a DVD with software, that is also fair use because it's illustrating an argument about film. Or, I mean, it should be. So I have to make sure it's doing that. So those are like the basic guidelines I use. So I guess it's sort of cut and dry, but I mean, some people could argue that a quote of poetry isn't being sufficiently explicated in a certain use. So I just have to make sure that's covered.
If I
And
may.
this is a particular press, Oxford University Press, which is a very major press here in New York. Not every press necessarily has the same perspective. So there might be different. And partly what we're trying to do is organize our own thoughts about our group of users, which are modern literature scholars mostly, so that we can send a signal to presses to begin, so that maybe there's not such a quarreling diversity of interpretations among presses of fair use. It might help with that.
I think what Brendan describes very modestly is in fact an excellent set of editorial practices around this issue, because although he doesn't have and couldn't have any rule of thumb with, 6 words is good and 3 lines is bad or whatever, sort of like what Kevin described earlier in his nightmarish experience with Columbia, what Brendan has described is a thought process, a rubric, a series of considerations which, when taken into account, leads to a robust, defensible conclusion about fair use. And it's really to that these documents that I was referring to earlier, these best practices statements, aspire. If anyone's interested in learning more about them, by the way, they're all collected and explicated at centerforsocialmedia.org, and you can read them there. And what you'll see is that they don't describe hard and fast rules or even attempt to. They describe ways of thinking through to a robust, defensible conclusion about whether a particular instance of use is or isn't fair.
Let me go further and plug Peter's recent book, which he has published with Pat Aufderheide, whom he referred to. And this is a terrific book, came out in 2011, University of Chicago Press, Reclaiming Fair Use, How to Put Balance Back in Copyright. And this not only describes, this is a great book if you just want to learn about fair use. It also tells you about what Peter has just been describing, and that is this movement towards best practices, and describes it in great detail, and actually gives you a sample or two of the best practices in the back. So.
Still a concept of public domain, and is it have legal boundaries, or is it fluid like this?
The question is there still a concept of the public domain, and does it have legal boundaries?
Is it have strong legal boundaries, or is it more fluid and interpreted like this?
Well, I think in many ways you could say that the public domain has more legible boundaries than fair use does. And I think Peter has mounted a really persuasive and influential defense of what gets called the vagueness of fair use, but which we could also think of as its elasticity. The public domain is a kind of moving wall, right? So that now in the U.S., pretty much everything published up until the end of 1922 is in the public domain. Works published between the beginning of 1923 and is at the end of 1977, is that correct? Are under copyright for 95 years. And then in later periods you measure copyright from the death of the author for a certain number of years after that. So the public domain has a complex geometry, right, that depends on the moment when a work is published, the conditions under which it's published. In some cases, and Bob can actually speak more to this, heretofore unpublished works, right, have their own kind of complex relationship to copyright and consequently to the public domain. But of course, it can be hard when you're talking about a particular work, right? I'm talking about works in the aggregate, right? But it can be difficult when you're talking about a particular work to know if it's in the public domain because of certain phases in U.S. copyright history that required people to renew copyright, right? And so if you don't know if a work's copyright has been renewed, it can be difficult to know whether it's still protected or not.
Something else to think about in the public domain is active efforts by certain people to create a public domain of their work by, for instance, a device called the General Public License. It's not strictly speaking public domain. It's actually copyright holders trying to say, here, I don't want my copyright. You can use it as long as you don't go lock it up yourself. So there are private actors trying to make a more generous public domain, not just for the older things where copyright term has lapsed, but for contemporary works. And in some communities, in some artistic and scholarly communities, that's quite vibrant. You should also know that there are certain limited categories where you cannot get a copyright. For instance, you can't own a copyright in fact. You might be able to own a copyright in compilations of fact because you've put a little creativity in. So there are limited, you can't have a copyright in an idea. So that little bubble that comes out of my head, as long as it's not fixed in fixed expression, it's still unowned.
Until you patent it.
Until I patent it. I've never had one of those. Too bad.
There are other really interesting examples of that, which are important to know about. So, for instance, works produced by the United States government go straight into the public domain without passing go, and that hasn't changed fundamentally over the history of copyright law. What has changed are some of the other ways in which works used to enter the public domain. There used to be, as has already been suggested, quite a lot of sort of detail work that was required to secure and perfect a copyright, in particular the use of a notice in connection with publication. So all of that is now over, essentially, and works no longer enter the public domain because there was a failure on the part of the copyright owner to comply with so-called copyright formalities. Indeed, some foreign works that were in the public domain for that reason have actually been restored to copyrighted status in the United States. We've actually raided the public domain to put works of foreign origin, under some circumstances, back into protection. And likewise, it was formerly the case, as I suggested earlier, that term limitation was a really meaningful source of new material for the public domain. The problem with the moving wall is that it's stalled, and it hasn't moved in a long, long time, and it may not move again. We're going to see in the Congress sometime in the next 2 or 3 years another battle over whether or not to further extend the term of copyright. So the public domain is real, but the official public domain is real, but it is diminished by virtue of all of these developments. And by contrast, as Kate points out, the voluntary public domain, the private public domain, if that designation makes any sense, is very important. And of course, one of the best examples of it is the increasing use of the Creative Commons license.
I like Paul's metaphor of a complex geometry, because there are other factors that go into thinking about this, like orphan copyrights, for example, knowing that rights exist but not being able to identify their holders, not understanding the whole history of how an object's rights have been owned or passed down. One of the things I do is create digital editions of magazines from the early 20th century, for example, and there's no way for us to go past 23 even if we wanted to, because imagine trying to track each right for each article, which may have been held in one case by a magazine, perhaps by a family, by an individual. I know this was an issue for the museum people as well, as sometimes we know rights might exist, but we can't find them, and so can't secure permission to reproduce them.
So I want to speak to that for a minute, because this problem, the orphan works problem, as you've just heard it described, is a besetting difficulty for a lot of people, especially scholars and teachers who are interested in making use of material which has no residual commercial value, that no one has any reason to actively exploit, but which is still technically under copyright. And there have been efforts to address that problem through legislation, which have been unsuccessful. The organized copyright industries, even though they had no particular stake in this issue, decided ultimately, the last time this came around in Congress, they just wouldn't tolerate any new law that diminished the force of copyright in any way, even when it might benefit them in particular circumstances. So it doesn't look now as though we are going to get anytime soon a really good legislated solution to this very significant orphan works problem that arises when copyright is long and, in fact, memory is short. So this is yet another area where the fair use doctrine has enormous potential to be applied. And, in fact, we're currently working on a little fair use best practices in orphan works activity, which is designed to address that. Jennifer Urban, URBAN in particular, has written some wonderful stuff recently about fair use in orphan works, which is very much worth reading if anyone is curious about how that problem and this solution might come together in a happy marriage.
And I would just add to what Sean said earlier. For libraries, for archival collections, for museums, the issue of orphan works, and particularly one of the things we grapple with at McFarland Library, is a huge number of photographic collections. And when we cannot identify the photographer. In fact, we got crosswise with the rights holder of an archival collection we own when a scholar was writing a new book on this particular author and wanted to use a photograph that was from our collection as the cover. And the rights holder got very upset until we pointed out, well, we can't establish who the photographer is, and unless you can, then it's an orphan work, and we're not going to contest it, and that solved the issue. But it's a very important issue, and it's very, very difficult to determine who that rights holder is, so many times.
Add one little point. Obviously, the mention of the public domain has just stimulated us to chatter like crazy, but that always happens. Let me add one little point, and this picks up from both Paul's remarks and Peter's. Paul referred to these older copyrights here, and the American public domain, which is, for me, a fascinating thing. It is a rather unique public domain in many, many ways, because our copyright law for so many years was different from the rest of the world. Because of these formalities that Peter referred to, that is, particularly the requirement that you had to attach a copyright notice to a book. You don't have to do that anymore to have a copyright, but you used to have to in the United States, and other things that you published and released to the world. And there was also something called renewal. After the first 28-year term, if you wanted another 28 years, you had to renew it within that last year of the first 28-year term, and you had to go through some formalities. You had to file an application for renewal with the Copyright Office and send a fee. Well, lots of people didn't do that. Many people didn't do that, and in fact, the Copyright Office has at various times done studies of this and found that vast percentages of works were simply not renewed. So I want to suggest, and we lawyers, American lawyers in particular, copyright lawyers, who do this kind of work for clients who have these needs, become kind of antiquarian attorneys in a sense, because we have to learn these old rules that some lawyers say, oh, it doesn't matter anymore, that's the old law. Well, no, the old law is still so important because, as Paul said, so many of these works published after 1922 may still be in copyright in the United States. However, because of these formalities, they may not be. And so, there are tools. We could talk about that a bit more, but there is, for example, a Stanford University website that you can check on whether a work was renewed or not. Now, these are not infallible tools, and also they are not necessarily complete tools. So I don't want to give you the idea that you can just type something into the Google and find it and have your answer. But I am saying that with a little research, maybe with a few hints from a lawyer, you could screw the microscope down on a particular need that you may have for an older work, and you might find that it is indeed in the public domain, the American public domain. There was a hand up, yeah.
So I feel like the elephant in the room is Mickey Mouse. And what I'm curious about is, well, one of the stories that us humanists like to tell each other and tell ourselves is that the Disney Corporation is largely behind this massive extension of copyright terms in the United States. To what extent is that true? To what extent is it true that, corporate lobbying is responsible for this sort of increasing diminishment of the public?
I should just, because I know Peter wants to jump in. I want to say something about Peter that all of you, I said this yesterday when I was introducing him to our faculty for his talk to our faculty, and that is, if you're familiar with a phrase, and you may well be, and you Google it and you'll find it, it'll pop up quick, that that what our Congress is tending towards is perpetual copyright on the installment plan. Peter invented that in congressional testimony when he was speaking in testimony about the then proposed extension of copyright terms, which became real. And then I'll just...
Does he permit you to cite it just now, though?
No, it's going on my tombstone.
Yeah. Yeah.
So it's a really good question. And I think that Disney and Disney's desires have been very useful metaphor in this discussion of term extension. But I think it oversimplifies the real political dynamics of this story considerably to put so much focus on Disney. Disney was really only one of a number of copyright interests who lobbied hard and effectively for term extension. At least as important in the overall picture were representatives of various music industry interests who are just as interested in keeping protection in place for a certain number of perennial musical standards as Disney may be interested in keeping protection in place for its crown jewels. So it sort of misstates somewhat the real dynamic, and hence doesn't help very much to prepare us for the next go-round on this issue to put all of the focus on Disney. There's plenty of blame to go around. The greatest problem, however, was not on the side of the lobbyists, but on the side of the legislators, most of whom simply do not understand why copyright should be subject to any outer limits. And that's at least in part because of the pervasive trope that associates copyright with property in things and in land. Because, your property in a chair doesn't run out until the chair is demolished, and maybe not even then. And your property in land is likewise indefinitely transmissible and inheritable. And the hardest, I've done it as Bob points out, and so I can tell you from personal experience that the hardest thing to communicate to a typical federal legislator or staff member on this issue isn't why it may be unwise as a matter of policy to extend copyright for another 20 years. It's why copyright shouldn't be perpetual. And so we're dealing with something very primitive here. And we need to acknowledge that primitivism, I think, in order to prepare ourselves for the next round of this battle on term extension, which I think, incidentally, is winnable. I think that it is quite possible to generate sufficient public outrage the next time this proposal is made so that it can actually be turned back in the same way that the SOPA and PIPA initiatives were turned back. But no one should think that it's not going to be hard work, and no one should think that it can be accomplished by focusing exclusively on the evils of the empire of the West.
I would just add that I think one of the reasons Disney has become such a long-legged meme in respect to term extension is actually it has to do with its deployment by critics of copyright term extension. Not only because of the mouse and Steamboat Willie and the way those figures, sort of branded licensed figures, consolidate things, but also because of the way that Disney is so reliant on public domain narratives and figures in its generation of new property. And so, everyone has seen the Disney films that are based on very old fairy tales. And so it's, I think, a very stark reminder of the sort of two-facedness of rights holder sovereignty claims on the basis of, or rather given how dependent rights holders are on pre-existing property, right, for their own fresh creation.
Could I just chime in here? But the question provokes another thought in my head, which is that it's not, if one is interested in the public domain and fair use, it's not a good idea to take your eye off corporate interests, particularly the gateway industries, whose business models depend on their ability to control vast amounts of content. And one of the rhetorical moves that industry has exploited in American politics is that they invoke regularly the interest of the individual creator. They've gotten Bob Dylan up to talk about how sacrosanct his song copyrights should be. So they invoke the notion of the individual creator and his rights and his expression and the importance of his being able to provide for his family and generations beyond him. At the same time, they are not the creator industries. So, Google and Amazon and all these big operators have lots of interest in copyright, but they use the idea of the individual creators, the author's needs, as a way to expand the appeal of what is otherwise simply an effort to solidify and expand their business model.
I have a question primarily to the humanists. And Dr. Detmar, you touched on this, and Dr. Santa-Moore, I know you lost that. But how has copyright affected the production of original creative works, especially works that rely heavily upon intertextuality, such as this?
Well, Paul will be able to give a fine-grained answer, so I'll give a blunt one, which is, I think, in some ways it's almost incalculable, because I think there were graduate students who were discouraged from even ever embarking on such projects, right? There's such fears, whether justified or not, fears about dealing with the Joyce estate, say, that, an advisor will say, work on somebody else, work on something else. We all know stories about individual projects that have been stopped. I would probably be indiscreet to talk about them specifically. And Bob could talk about Carol Schloss's book about Lucia and Finnegan's Wake, which, the impetus for that lawsuit was that my scholarship has been deformed because the estate has refused me access to the evidence that I need to prove my scholarly claim.
You mentioned the example of Ulysses, which is a fascinating one to me, given how thoroughgoingly intertextual that book and a number of contemporary works contemporary with it, which we consider to be sort of high watermark modernist texts. And I think that it would be more difficult to get a work like Ulysses published in the current climate, given the kind of permissions culture in which we live, right? If you went to a trade publisher and you took them a work that had 25 quotations on every page from some pre-existing work, many of which were still protected, not all of them, you'd run into a very different kind of trouble. Joyce ran into trouble because of the book's putative obscenity. I think the trouble you'd run into now would be the trouble of what we've come to call private censorship, right? Which is the power of estates to say, no, you may not publish this, even though it's not obscene. We will just deny you permission. that having been said, we all can think of, works that are intertextual and that are contemporary ones, new things, and Kevin mentioned several good ones. So I think it's fascinating to watch the way creators work around. This is something that Bob has actually written about, work around scholarship that sort of works around the impediments that copyright creates. But also, if you imagine the creative and scholarly works that didn't come into being, and also the impossibility of measuring them, right? I think you become newly acquainted with the sorrows of all that is prevented by strong copyrights, right? You almost don't know what to deplore or mourn because it leaves no trace, or it leaves very little trace.
I would just add to that on the question of Joyce, Joyce, because of our very strange and complex U.S. copyright law, enjoyed no copyright in Ulysses. But there's a sense in which he had a super copyright. It was provided by the obscenity law, because nobody could publish Ulysses in the United States, including Joyce. That's a very strange kind of copyright that prevents even its author from publishing it. But I would add, if you want to pursue this, you should read, if you haven't, Paul's wonderful book called The Copyrights, which includes I think it's an appendix, isn't it, or an epilogue? Epilogue, the thought experiment about.
It's in the chapter.
You got it's some chapter on Joyce. Okay, as a wonderful thought experiment about what if Joyce had to go get the kinds of permissions back in 1918 when he was starting Ulysses, or in the full course of writing it. What if he had to get the kind of permissions that nowadays we have to get? So
let me add an interesting example from the domain of popular culture, which has been wonderfully and I think very persuasively documented in a book called Creative License by Peter DeCola and Kembru MacLeod, who are writing about the history of sampling practice, especially in regard to hip-hop. And what I think Peter and Kembru demonstrate quite convincingly is that there is a very significant difference in character, and some might argue in quality, between first and second generation producers of hip-hop. That sampling in first generation hip-hop, which tended to occur without regard to constraints of copyright, which was more or less an underground phenomenon, is much richer, much thicker, much more layered than the thinner sampling, which occurs in a largely regulated licensing regime in second generation hip-hop. We also found, incidentally, in talking to poets as part of the work leading up to the Poetry Foundation Fair Use Best Practices, that there were many poets who were interested in different kinds of remix, who were either being warned off that territory or who were facing considerable obstacles in making that work publicly available as a result of clearance culture. So these are real effects, but I agree entirely, and I want to echo what Paul said earlier, and that is that the greatest effects are probably the invisible ones, the projects foregone, the works not attempted. And although we can try to get at those losses indirectly, we will never be able to take their full measure.
Do we have one or two more questions? Any others? Yes, in the back.
I have a question about the internet and how that would affect fair use. Because people now have the ability to take reproductions of images, quotes from literature, and post it in near invisible sites often. So how does that sort of complicate or, I don't know, maybe add to this discussion on fair use and copyright material?
Well, let me say that I think absolutely nothing changes. That the beauty of fair use as a legal doctrine is that it is comprehensive, flexible, dynamic, accommodating to new technology. That the question about online uses is exactly the same question that arises with respect to physical uses. That is to say, can these uses be justified as meaningful transformations of the material taken, to which the makers or the new use have brought an appropriate amount of material from the source. The only thing that changes is that we get a whole set of wonderful new examples of fair use practice, of which many of the eruptions of remix culture that the internet seems to facilitate are outstanding ones. But we're talking about a unified field theory here. It should not matter where the use takes place, in physical or virtual space.
Laura?
I just have a follow-up question. Are there issues of international differences in usage or the location? Because the internet would just bring us more readily and quickly across national lines. It runs it in the road.
I think there are two questions to sort of unpack from that. It's a very interesting question, because U.S. fair use law is not the law of the world. There are other fair use jurisdictions in the world. There are other jurisdictions that have other kinds of very important flexible limitations and exceptions. There are still other national jurisdictions that are moving toward them. But broadly speaking, fair use is a U.S. specialty. U.S., Israel, Philippines, to some extent Singapore, and a handful of other countries have it, and others do not. The question then becomes, what law controls when an instance of claimed fair use is being decided? And two things are clear. One is that where the work originates is irrelevant. The other is that if we're talking about a use in physical space, distributing copies of a book or copies of a film, or teaching a class, it's the place where the activity occurs which matters. There is some ambiguity around the question of what law should control in the case of online uses that originate physically in one place, wherever the originating server is to be found, but which are accessible in other places. And that issue has yet to be settled. Mm-hmm.
Let me add one little tiny point, and Bob, you go ahead.
I represent, or I work in the museum world, and by nature we're a conservative bunch. When we're talking about images, for example, that you can take from the museum, museums are interested in the copyright, and we understand that we don't own the copyright to all of the works in our museums. Sometimes works are on loan to us, so the lender or the artist still has the copyright. The living artist may have the copyright, or there may be a whole series of answers to that question. So it used to be, before the digital age, that if you said to someone who wanted to take pictures of paintings or works in your museum, well, you could take a picture, but you can't use a flash, can't use a tripod, and you could restrict people from creating publication quality photographs. So that was an effective tool at the time. Today, irrelevant. Your smartphone can take pictures that are nearly, if not truly, publication quality. And it's an issue that museums struggle with, because we really give copyright if we don't, in fact, own it ourselves. And there is an issue of loss of control. There are sites you can go to, and you can buy copies of paintings in the Gilcrease Museum. It's not our site. Somebody else has taken those. Now, hopefully, those are pictures that are in the public domain, but that's not always true. So it's an issue, and as an educational institution, museums are on the side of expanding access to information and knowledge and images and all those sorts of things. But as a practical matter, we also want to have some control over those images, or at least try to prevent people from violating certain laws or norms. So that's that's a complication of the museum world.
If I might, this question reminds me of the first question that was asked about whether it was still permissible to make private copies for one's own use. And I think a question about the web, internet sites, raises this, particularly in the area, for instance, of fan fictions and people who are sort of reacting to other works out in the culture and then creating their own sites. And the divide there between the purely private, the student who goes and makes a physical copy of a book and takes it home to look at, and my Facebook page where I may be, making collages of all sorts of copyrighted works. I don't think many people in the culture who haven't been to law school understand that private activity on your Facebook page may not be regarded by some copyright holders as being the same as the single copy. And Peter's completely right that the principle of fair use is uniform across, but though the copyright holders are much more threatened by both the possibility of massive distribution of digital materials and also massive viewing if someone chooses to make stuff available. So the public-private, the old physical copy world, public-private distinction has gotten terribly, terribly muddy and complicated this issue.
I would add that there is one sort of shibboleth that I would like to lay to rest before we part today concerning this issue of digital accessibility, because quite often I run into very responsible institutional actors in museums or in libraries or in schools who are genuinely concerned that if they make material available online for purposes that are entirely legitimate, mission-critical, fair uses, they may still somehow incur liability as a result of less responsible downstream uses that others make of that material. And there is simply no warrant whatsoever in the law for those fears. There is no legal doctrine today which would permit a copyright owner to pin liability on a library because someone third hand got a hold of an image that had been posted on its site and inappropriately commercialized it or traduced it or otherwise behaved badly. And let us hope there never will be.
Yes, one more last question, Nita.
Please, can you speak to the subject of unpublished documents such as old personal letters and other similar personal artifacts, which could be used as historical or biographical compilations or narratives?
You know one or two things about that, don't you, Bob?
And I'd be interested to hear what others have to say. As far as from a fair use point of view, we have come a long way from about 30 years ago or so, 25 years ago, when there was great concern about the use of unpublished documents, especially private letters, diaries, such things as that, because a couple of cases had been decided, 3 or 4 cases. It began to seem that there could not be a fair use of unpublished works because there was this kind of aura of privacy or of specialness to unpublished things. There was a fear that you were maybe prying into somebody's life. But it's really no longer, at least in the law, the Congress stepped in and made clear that there should be no special status for unpublished works. So certainly unpublished works are subject to fair use nowadays. Of course, what you want to find out is whether these old works are still in copyright, because they might not be. So you might not have a fair use issue at all if you discover that it's so old that it's already passed out of copyright.
I'd agree completely with all of that. and add one thing in addition, and that is that with respect to issues like significant quotation from unpublished documents in scholarship, I think that issue is essentially behind us. It's clear now that fair use applies to that activity as it would apply in a similar way to quotations of published works. The edge issue, I think, relates to the fair use status of projects that are intended to make significant amounts of unpublished documentation, some of which we will assume for purposes of this argument may be protected by copyright, available online in their entirety. And there, it is worth consulting, I think, the Research Library's best practices document that I mentioned to you earlier, which takes a fairly strong and a fairly positive position on that proposition, subject to the argument or responsive to the argument that significant curation of a collection of otherwise inaccessible unpublished materials is in itself a significant transformative use. So that is, I think, if you want to know where the frontier is on this question, that is the frontier, and I think it's moving westward.
Thank you very much. Thank you all for coming.